So, good morning, everybody. My name's Henry. I'm from the Chamber team. I'm joined today by Paul Abdey, who's a partner in the commercial litigation team at Brachers. Brachers are also valued patrons of the Kennewick's Chamber. Welcome to Business Bites. Our host, like I said, is Paul Abdey, who I'm now going to pass over to. So, Paul, feel free to take it away whenever you're ready.
Thank you, Henry. That's great. Good afternoon, everyone. I hope you're all well. I've been asked by the Chamber today to produce just a short talk on the topic cash is king, as you can see from the slide. Obviously, cash flow for any business is important, and even more so given the current economic problems we're encountering. So hopefully this talk will give you some guidance and tips to hopefully improve your business's cash flow. Just a little bit about me. Obviously, my name's Paul Abdey. I'm a partner in the commercial litigation team. I've been at Brachers, who are based in Maidstone, for 21 years, and I focus solely on debt recovery and insolvency issues. So hopefully I can give you some tips moving forward for your business. So let's move on the slide. So this talk is going to take you through the flow from taking on the debt to try and hopefully getting the debt paid and any steps in between. So credit control I will be focusing in on, but I'll also be talking about other elements of the cycle of the debt, from taking the customer on through to potentially legal proceedings. So first of all, before you even take a customer on, have you considered what your terms and conditions actually say? By this, I mean, do you consider how you protect your business in the instance everything goes wrong and the customer doesn't pay? So do your terms include, and for some agreements I've seen don't include payment terms as to when invoices are to be paid and the customer doesn't have that expectation? Secondly, do your terms include provision to recover legal costs or recovery costs if all goes wrong and the invoice isn't paid? And allied to that, do your terms also include coverage to add interest at a prescribed rate if the invoice isn't paid on terms? If it is a business-to-business debt, and I'm approaching this as it probably is likely to be a business-to-business debt, and your terms don't include recovery of costs or interest, then you can rely on the late payment legislation. So it's the Late Payment of Commercial Debts Interest Act. That allows you to recover a set compensation amount per invoice, and it's dependent on the value of the invoice. It also allows you to recover reasonable costs of collecting that debt, which aren't covered by the compensation. And importantly, it allows you to claim interest at the prescribed rate, which is 8% above the Bank of England base rate. So obviously, with interest rates being so high, you would be able to claim interest at quite a high rate under the late payment legislation. So that's something to think about. Even if your terms don't include provision for interest, you can still claim that on a business-to-business debt. But of course, if you want to, you can add prescribed terms to your terms and conditions, which allow you to claim interest at a rate you want and also allows you to claim costs if you wish. So you have your terms and conditions, but how do you incorporate those terms into the agreements with your customers? So many times I see wonderfully written terms and conditions, but they're forgotten about when you actually contract with your customers. So it's important to note that when a customer comes forward to you and asks you to produce service or ask you for a quote, but at that point, you bring your terms and conditions to your customer's attention, or you bring your customer's attention as to where those terms can be found, i.e. a website link or an email link or something of that. So that way the customer knows what the terms are they're agreeing to, and if it comes to enforcement of those terms, there can be no argument those terms don't apply to the agreement. So that's an important point. I've also added on the slide, be aware of a battle of the forms. Now, this means where there's two competing terms and conditions, which one takes precedent. It wouldn't necessarily affect a smaller customer. It is more likely to be when you're dealing with a larger company who have their own all singing, all dancing terms and conditions. The basic rule is the last set of terms and conditions which are exchanged will apply to any agreement reached with that customer. So, for example, you send your terms and conditions in saying, we're going to quote for this and these terms will apply. But the customer then says, thanks, we want to order with you, but here's our terms, they apply. If you then go on and undertake that instruction, it's the customer's terms that will apply and not your own. So something to be aware of and think of when you're at the contracting stage of dealing with a customer. So just going to move on. I think it's very important to understand that the credit control process starts when you're first speaking with your customer. So you have your all singing, all dancing terms and conditions. You're incorporating those terms and conditions into your agreement with the customer. But what else can you do when you first start talking to your customer? And I think this is where there's an ethos within a business that not only the credit control team deal with credit control, but the sales team at least appreciate how important their role is, which may pass down to credit control at a later point. Obviously, your sales team is the first point of contact with the customer, and they are going to want to build an effective relationship with that customer, but not only from a point of view of selling items to them, but from a point of view of getting sufficient information from them to allow your credit control to then be effective if and when needed. By this, and a little diagram here to explain better, if your sales team know and obtain this information on this diagram, then that will make your credit control teams work at a later date so much easier. So let's break this down a little bit. So firstly, your sales team should be able to obtain full information about the customer, including their legal identity. So often I see agreements where they say Joe Bloggs, for example. Now, who is Joe Bloggs? Is Joe Bloggs an individual? Is Joe Bloggs a limited company, etc., etc.? So if your sales team know the importance of obtaining all the information on the customer and explaining, are they a limited company, are they an individual, are they a partnership, whilst that information might not be important to them in obtaining the sale, it will be important to your business as a whole. Likewise, although you may obtain the legal identity, have you obtained all necessary contact details for your customer? If your sales team go in just to obtain a sale, okay for their commission, but haven't obtained details of the individual who acts in the limited company, details of the telephone number, etc., etc., then that's going to make your credit control team's job even harder if and when it gets to that point. This might not be a job for the sales team, but it's certainly something they would need to think about. If you're contracting with a limited company, would you ask necessarily for a director's personal guarantee? Now, this will come down to a policy within your own business, and it might also be linked to whether you do credit checks on a company to see if they're worthy of providing credit to. But ordinarily, I think it would be a good idea to ask for a director's personal guarantee, even if you don't have to rely upon it. Who knows what might happen? You might contract with a company for years, relying on the same set of terms, or something could change immediately once you've sold items to a company. It's always a good idea, in my view, to have a fallback provision. Otherwise, if a company just goes into liquidation or falls over some other way, you would only be limited to claiming in that insolvency. Whereas if you had a director's personal guarantee, at least you could then look to recourse from a director and not just the company. So that's something to think about. And I do have clients who do, as a matter of course, seek a director's personal guarantee. It's just a fallback provision if the company aren't good for the money. So if the sales team have undertaken all necessary steps as discussed, and then the credit control team have to then start working if the invoice goes unpaid. In my view, credit control is a balance between obviously getting cash in, very important, what we're talking about today, but also can be used as a tool to improve your business and possibly even force sales through your business. Whilst credit control has been viewed historically as a hammer, as a way to force customers to pay, it could also be used as a way for your business to effectively communicate with your customers, to know what your customers want, what your customers need, and possibly to force future sales. By that I mean, of course, if you're ringing up saying, can this invoice be paid, please? And the customer says yes, but we need X, Y, and Z. And of course, you could say, well, pay the invoice, and we can look to then provide you with future sales. It would also, of course, where your credit control team is speaking to the individuals, of course, all the details provided by your sales team, they hopefully will give some indication of troublesome accounts. So not only would you be looking at future sales, but you could be looking at ways to say, no, we're going to put a stop on this account because there is an issue here which we believe could become a big issue and will stop payment being made. So credit control isn't just a way in which to force cash through your business. It can also be used as your business to hopefully grow and effectively communicate with your customers. And of course, there could be an issue where credit control have find out there was a problem with the goods or services provided, which may not have been raised until that point. So effective credit control is not only forcing cash through your business, but it is also communicating effectively with your customers. So how do you implement a credit control procedure for your business? Well, there's no one size fits all for credit control procedures. It's very much on an individual basis, and you will know your business, and so you will know as and when you can enforce or this type of credit control procedure you need to put in place. What I would say is implement a framework and stick to it. There's no point having a framework where you send so many letters, so many emails, so many telephone calls, but only use it for so many accounts and not all the accounts. Have a framework and use it. As a general rule of thumb, I would suggest not having any more than 30-day credit control turnaround from date of invoice. So I would suggest maybe a week to 5 days before the invoice is due. Credit control picks up the phone, sends an email saying, by the way, this invoice is coming due, please arrange payment. Then if payment isn't still not made, a few days after the invoice has fallen due, again, a telephone call and or a letter to up to the point of, say, around 28 to 30 days from the date the invoice has fallen due. Within that time, I suggest maybe 2 to 3 phone calls, 2 to 3 letters or emails. By that point, you will have A, flushed out any issues or problems with that invoice, and B, you will know that you're then able to move forward with pursuing further action if you need to. So don't leave it too long. The longer you leave it, the harder it is to recover, in my view. So build a framework which works for your company. I've said use it for every customer. There's always going to be the exception that proves the rule. For example, if you've got a very long-standing customer who you know wouldn't necessarily react well to this sort of framework, then you'll know when not to use it. But 99.9%, I suggest that any framework you build, you use and use properly. And my last point there, which is also a point in legal action, which I'll discuss in a minute, is do not make idle threats. If you're writing to customers saying you need to pay, otherwise further action is going to happen, and then further action doesn't happen, then of course they're going to know that you're just making threats which aren't essentially you're going to follow through on. So what is the point? They're going to keep their own money and not make payments. And of course, that sort of situation can also get around your customer base pretty quickly. So they know that that you're asking for payment, but what's the point? Don't need to pay because you're not going to follow through on your threat. So keep that in mind. If you're going to say you're going to do something, then I certainly suggest you do it on the vast majority of cases. So what if a customer fails to make payment despite that whole process? What do you do then? Well, the first port of call, and it's not covered on the slide, is that in my experience, around 60 to 75% of cases where it's gone through a business's credit control procedure, it then reaches a solicitor's, ourselves hopefully, door. We send a letter before action on behalf of that business, and then the customer picks up the phone, emails, because they realise things are getting serious. Whether or not that's to make payment, come to an arrangement, or speak about an issue they have is another matter, but at least you would then have communication with the debtor. So a solicitor's letter does have more effect, in my experience, than just a customer's business's letter before action. If that letter before action is sent and the customer still doesn't make contact or wishes to try and to discuss ways in which to settle that, you would then be left with two options. The first option would be to pursue legal proceedings, and by that I mean a county court claim, and I'll speak about that now. So that is I'm sure you're aware, it's a court document, a county court claim. It sets out what you say is owed, why you say it's owed. That then gets issued by the court and gets sent to the defendant. If it's issued electronically by the bulk centre, we call it, then that, once served on the defendant has 21 days to respond to that. Now, a response can be an admission, a part admission, a defence. They have that time to make that call as to how they respond to the claim. If they fail to respond to the claim within that time limit, then you can obtain a county court judgment in default of a response. Once you have your county court judgment, you're then looking at proceeding with enforcement if you wish. You don't have to proceed with enforcement, rather. Once a county court judgment has been registered, that will affect that individual or that company's credit rating for a period of 6 years from when it's entered. We have had cases before where debtors have made contact 2, 3, 4 years after a judgment's been entered because they're looking to buy a property or this, that, and the other. So it can have that effect. But if you don't enforce, if you do enforce following the judgment, then by enforcement action, I'm talking about bailiffs, third-party debt orders, charging orders. That will be subject to what you know about the customer, and takes us back to the initial point about your sales team obtaining information about your customer, because at this point, once you know what your customer has potentially in terms of assets, if you've done credit checks, etc., then this will aid what you then do moving forward to enforce a county court judgment. And of course, that information will also help you decide which cases you invest in to pursue legal proceedings. Because I should also mention, legal proceedings aren't cheap. Even just to issue a claim, there's generally a reasonably high court fee. That court fee is added onto the debt, but obviously that's only relevant if the debt, including the court fee, is then paid. Otherwise, you could be throwing good money after bad. So knowledge is power in this game. If you know about the client, about your client, about the defendant, then you'll know how to enforce a judgment, and you'll know whether to undertake legal proceedings in the first place. The next route forward, probably for the larger debts, because insolvency proceedings are particularly expensive, would be to undertake a petition, be it a bankruptcy petition against an individual or a winding up petition against a company. Prior to taking that route, you would need to serve a statutory demand. That is not a court document. That is just a document and a prescribed form saying you owe this money, reason for you owing the money, and if you don't pay after 21 days from the date the claim of the stat demand has been served, you can then pursue an insolvency petition. As I mentioned, insolvency petitions aren't cheap. All in, including all disbursements, for a winding up petition where there isn't a dispute and there's only one hearing, you're looking around £4,500 plus VAT, and that includes the disbursements, which is called an official receiver's deposit, and that's £2,600. So it's only for the right debts where you should take this route. Otherwise, you could be throwing very good money after bad. Insolvency proceedings will only be worthwhile if you believe that the mere threat or indeed the petition itself will force payment. If it doesn't force payment, and in the case of a winding up order, the debtor company just falls over and allows itself to be liquidated or wound up, then your debt will rank alongside all other unsecured creditors when it comes to any dividend being declared. I'll comment on insolvency a little bit more in the next slide. So in other words, insolvency petitions only worthwhile if you know there are assets to be realized, or if you know, or if you want to force the petition for another particular point or reason. So as I said, I was going to comment on insolvency petitions a little bit more in this slide. Insolvency petitions, once an order is made, it is likely that you won't see any payments. If you do, for a number of years, an insolvency practitioner, once an order is made, will be appointed, be it a liquidator to a company or a trustee for a bankrupt, and it is likely will take many years to realise assets for the benefit of the creditors of the estate. As I mentioned, your debt would rank alongside all other unsecured creditors in both a bankruptcy and a winding up situation, albeit your costs of the petition will be paid first from any asset realisations within the estate. If you get to a position where you have a case, you don't know whether there's any assets to be realised, but as a point of principle, you want to wind up a company, for example, it's not necessarily the end of the world in terms of getting paid. I would suggest that you write off the debt for the purposes of your accounts rather. But insolvency practitioners do have powers to review transactions which have occurred a number of years before the order's made, and can possibly overturn those transactions for the benefit of creditors. Liquidators can also look at any issues, any ways in which the directors of the company have run the company, which could potentially lead to personal liability for the directors by, for example, wrongful or fraudulent trading. So that's another element. It's not necessarily you won't get any payment, but you should view it as you're not going to be getting paid, and any dividend paid is a bonus. And in a bankruptcy situation, generally speaking, the main asset is a property. If it's the property in which the bankrupt and or his wife and or her husband were living at the point the bankruptcy order was made, then a trustee can't do anything with that property for the first year. So again, any dividends that may be paid are likely to be paid a number of years after the order was made. So the final message to take away from this really is know your client from the outset. Make sure your sales team know exactly the information you need. And it's not just information to obtain the sale, but it's information which may be needed in the future for your business to not only obtain payment, but also to take legal action if necessary, and to understand which cases you can invest in and which cases you really should just say, well, it's a bad lot, we just need to write it off. So thank you for taking the time to listen to me over lunchtime. Are there any questions?
Perfect. Thank you very much, Paul. Like said, any questions, feel free to put these in the chat. Equally, if you'd like to unmute and just ask away, that would be great as well. So if anyone has anything, feel free to ask now. Anyone got any questions? Not right now. I do actually have a question, Paul. So obviously you say that the collection is very much customer based.
Yes.
Do you have, is there ways of maintaining a good sort of relationship past debt collection? And how would you suggest doing so?
Do you mean a relationship with a customer you've taken, for example, to court? Is that well, I suppose that brings two points. Firstly, I mean, do you want to continue a relationship with somebody you've taken to court? But secondly, you could view it as that customer now knows you're not going to be playing games. You are going to do what you say, and you're going to follow through to recover monies that are rightfully due to you. So that could improve the professionalism potentially of the view that your business is professional. It will do what it says it will do. It's going to be paid what it is due, and so they then may want to continue trading with you because. If you want to trade with them, but if they view as a professional business, they want to continue trading with you, and they're not going to, upset you in terms of making payments in future, hopefully.
Perfect, thank you. Yeah, if anyone else has got any questions, feel free to unmute and ask.
Hi there. I'm just wondering, when you decide you're going to take somebody or you want to threaten somebody to the next level, who are the approved companies to write the solicitor's letter?
Do you mean who you should instruct in terms of solicitors?
Yes, because obviously, as you quite rightly said and continue to say, you don't want to be throwing good money after bad, but you want to make the intentions very clear that you want to be paid and you want to try and do it the cheapest way, but the most effective way.
Well, of course. I mean, obviously, I would say Brachers are your best bet in that sense. But of course, I'm going to say that. I mean, in terms of finding other solicitors that specialise in debt collection, there are there's the Legal 500 rankings. Basically, law firms will have a ranking. It is a book, but I think it's online as well, where you can look up specialist debt collection. You can look up by areas, and you can look which firms are ranked in the top rankings. So that's one way to do it. Of course, another way is just Google, debt collection solicitors in a particular area. You don't need to be specific, as in terms of looking for solicitors in a particular area close to you. You can, if you wish to, obviously attend those personally, but there's no need to, as everything's obviously virtual at the moment in any event. So yes, I mean that's two ways I can think you can find a solicitor. But look at the rankings is probably the best bet.
Okay, because quite in previous companies, everyone seems to use Thomas Higgins as the general go-to because they're quite reasonably priced.
It depends what you're looking for. Somebody like Thomas Higgins, Lovett, for example, they do run very much automated process where you don't get that conversation with an individual necessarily. I'm not used to myself, of course, so I can't particularly comment, but that's my understanding of their service. So you get a cheap price, but you get not a treadmill, but you get that sort of experience. Whereas Brachers more often you get to speak to somebody, you get to talk about issues, problems, etc. So that's the sort of difference you'd experience.
Okay, just one last question. Once this is all wrapped up, is there a video of this meeting that we can look at and review and take some additional notes if necessary?
I think Henry can answer that one.
Yes, so the session is recorded. It will be up on our resources hub on our website and on our YouTube channel sometime, hopefully next week. But yeah, it depends on availability to edit it, of course. But yeah, it is recorded is the short answer to that question.
And will we be sent a link, i.e. the attendees today, will they be sent, thank you for turning up to today's meeting. Here is the link if you want to review the recording, or do we have to search for it?
No, we can send that across to you after the session. That's not a problem at all.
Please do. I would appreciate
worries.
that. Thank you
No
very
worries.
much. It's been very useful. Thank you.
You're welcome.
No problem. And I've seen another question in the chat from Jane. So Jane, if you'd like to unmute to ask your question. Jane, would you like to unmute, or if not, there we go. Sorry, Jane, we can't hear you. However, your question was regarding other organisations such as education and government. Mic's not working. Yes, so it's regarding other organisations such as education and government. Is there particular processes? I'm guessing your question is around, does it change dependent on those organisations? Am I right in saying that?
Shall I answer that?
Okay, collecting money owed.
Right, okay. I don't have a huge experience of collecting money from government, local institutions, but my view is, does it change it? It shouldn't change it. You should still obviously be able to collect money in a timely fashion. It's about, in those large organisations, in my view, prior to legal action, it's about finding the right person to deal with the problem. Once you've found that right person, have a name, a telephone number, an email address, you generally don't have any issues. And generally speaking, it's going to be somebody in the accounts organisation, because there's no doubt the invoice is due to be paid. It's just getting it in front of the right person. So I think that's the key in that situation. And certainly where we've had to send letters before action to local government, etc., it is then getting on the phone saying, we've got this problem, who can deal with it? And those sorts of people badgering more than threatening legal proceedings just to get it before the right person.
Perfect, fantastic. Thank you very much, Paul. If anyone else has any more questions, we have time for maybe one more. If not, we will let you all get on with your rest of your day. Let's give it a moment, see if anyone has any questions. No, it looks like we are all finished. So thank you ever so much, everyone, for attending today's session. Hopefully you found it useful, and thank you again to Paul for hosting with us today. Like I said, the recordings will be sent out afterwards.
Thank you.